I'll mute the video.
Start video. Where is Simon?
Start my video. Yeah. She's ready.
Wednesday, the 25th of November, 2020, court via Zoom at 2:34 before the Honorable Justice Subair Williams, Appellate Jurisdiction 2019, number 31, Levince Roberts versus Fiona Miller. Mr. Scott for the appellate, Ms. Simons for the respondent. The matter is a continuation.
Milady, good afternoon.
Yes, good afternoon, Mr. Scott. Good afternoon, Mrs. Simons. Let me just have both of you introduce yourself for the record, please.
Absolutely. Ms. Simons, unmute yourself, Ms. Simons.
Thank you. Shaunte Simons from the Department of Public Prosecutions.
Michael Scott, counsel for Levince Roberts.
Yes, thank you. Mr. Scott, we are continuing from the hearing of the 30th of October. On that occasion, your client was present in the court proceedings. Is he going to be joining us for the remainder of the hearing this afternoon?
Milady, yes, he's here. And I would also indicate that my intern is here, Mr. Christopher Cabley.
Okay.
I've shared them out, but those are the
so they are outside of, I think, the scope of the camera, but they are present with you?
Yes, I'm looking at them.
Okay, thank you. And just to remind you, Mr. Scott, you indicated to me, having addressed the court for approximately 90 minutes on the last occasion, that you would be able to complete your submissions in a half-an-hour time frame. I'm going to hold you to that this afternoon. And I will expect to hear from Ms. Simons, who has also indicated that she will not likely be as long as you were in her oral submissions.
I'm very grateful, Your Worship, Milady, and I will be held. And I've thought about this matter a great deal. So may I just set the tone by indicating that the appeal issues to be
My lady, I'm sorry to interrupt, but I'm not sure if you have before you. I note that my learned friend submitted 11 more pages of submissions this morning.
Yes.
That were not previously submitted to the court or the Crown, and I'm not quite sure what these new submissions are for, especially because on the last occasion he advised us that he is near the end of his submissions.
Yes, thank you, Ms. Simons. Mr. Scott.
I could respond, yes.
I think you should. I hope that you've not attempted to put anything new. I have to tell you, I've not looked through what looks to be a very voluminous document.
So, my lady, they represent my thoughts in the interregnum of our last appearance and now. And I completely undertake that my responses today are going to be in relation to dealing with the issue of the law. I think that's where the real issues are. Now, the fact that I've sent you those thoughts, they reflect my analysis of this somewhat new area for us, milady, may I say. And we're looking forward, may I say with all respect, we're looking forward to your ladyship establishing a guiding rule in this decision so that drowsy motorist driving has...
Mr. Scott, let's get straight to the point, please. The complaint is that you have filed a very lengthy document under the heading of further submissions or to the like. I did not direct for you to do that. In fact, I have had pre-hearing directions where I've been very careful to manage what gets filed in advance of the hearing and what is not permitted to be filed. So I have to tell you, I was surprised myself to have received these closing legal arguments. I think you'll have to really explain to me why it is that you felt fit, you saw it fit to file documents at this point.
My lady, it was to assist the Zoom meeting.
It doesn't assist me. It doesn't, what assists the court is very clearly explained in the directions hearings, Mrs. Scott.
Yeah, my lady, I only have an half an hour, and I'm able to condense my thoughts represented by these 11 pages they actually came overnight. It is precisely what I would have said to my lady if I were standing before you. That's really what it is. I don't see how I can be tied to my submission. In fact, I hadn't, when we broke, I indicated to you that my intention would be to deal with Gosney, but having reflected on Gosney, your decision of Lauren Davies, and just a review of the judgment, how they apply to this judgment. That's what I'm seeking to do.
Mr. Scott, let me assure you, I reviewed the hearing of the 30th of October before we convened this afternoon. And I should remind you that what you actually indicated to the court was that you were going to address the court quite succinctly on the evidence. You said a half an hour period would be sufficient. You have already addressed me at length in respect of the authorities of Yimnes, Gosney, and how Hill and Baxter was disapproved. You have been quite thorough in your submissions on all of those points. I don't expect you to do submissions or anything of the like again this afternoon, given the indication by you on the 30th of October. So I am at a loss as to where you're going to go, but I won't waste any further time. It is now 2:40. You have 30 minutes. You can proceed.
I'm very grateful, my lady. May I say that there was no point in my going through the evidence in this matter. I was at the point of reviewing the law the last time. And my thought was that Gosney is the controlling precedent for this court, my lady, the controlling precedent. And Gosney, whilst not a case of drowsy driving, it's on negligence, the lady driving up the wrong way of the road. It establishes the principle that fault is an important element in cases under Section 37A of our Act, which is causing GBH by due care driving. Now,
fault is a very is an element, I think, in Gosney in relation to dangerous driving. Gosney involved a charge of dangerous driving.
I don't see how that lady would have been, well, she might have been charged with dangerous driving, but lady, as you indicated in your most recent decision in September last month.
Dennis Webb.
No, I have been unable to find Webb. Lauren Davis is what I sent to my lady and my friend.
And I referred you to the case of Dennis Webb, but Dennis Webb was, it was a similar charge. It was causing grievous bodily harm by careless driving. And the real issue in Dennis Webb was the grievous bodily harm and the meaning of it. The injuries were challenged. The careless driving was also an issue. And I think the parity.
So it sounds as if Webb and Lauren Davis are closely linked, because that's precisely what I was going to lift from the Davis decision. Mm-hmm. At your paragraph 11, you say that the offense of dangerous driving, the Crown has to prove not only that the accused manner of driving fell far below the standard expected of a competent and careful driver, but also that it would be obvious to a competent and careful driver that the driving is that way, that driving in that way would put someone in danger of personal injury or serious property damage. In assessing the facts, you went on, my lady, the court shall have regard to all the circumstances. Those are operative words, we could underline them. This means the court will apply a subjective and objective test. My lady, may I compliment you on that analysis? So we now know that Section 37A that the legislature passed must subscribe to judge law that there is a subjective and objective test to consider both the circumstances known to Mr. Roberts in this case and the circumstances which reasonably ought to have been known by the accused. Then you went on, my lady, at paragraph 12. The offense of dangerous driving is more serious than careless driving. While the former applies to an offender who has fallen, dangerous driving falls below the standard of an offender who has fallen below the expected standard. The offense, operative words meaning, of careless driving arises where the manner of driving merely falls below what would be expected of a competent and careful driver. So, my lady, in Davis, you extract that in dangerous driving, a critical element is exposure of the danger to public. Now, clearly, and I was, when I rolled back and looked at 37A of our Road Traffic Act, it seems to allow a most unusual situation of, for careless driving, you can have the same test of exposing the public to a dangerous, drowsy motorist as you would in dangerous driving. But that's the way matters stand, which is why I emphasize with the greatest respect, lady, that today's decision, I hope, navigates us through this legal territory. Why? Because in my respectful submission, clearly, and I was setting out the term, in Bermuda, Section 37A charges against a driver will only allow of a conviction where the prosecution proved to the court that the driver fell below that drowsy driving, in this case, occurred in a way that fell below the standard of a competent, no issue that Mr. Roberts is incompetent, and prudent driver. So, secondly, that Bermuda, this is really important, may I say, the Bermuda legal position is that after Gosnell, Section 37A is not an absolute strict liability offense. This is our primary complaint in this case, my lady, that strict liability, absolute strict liability that Lord Goddard spoke of, was applied by Ms.
Where do you say in Mr. Attridge's judgment
that he did that?
That he applied a strict liability type approach?
Sure. First of all, if we go to his judgment, when you have it, my lady.
Yes, I have it in front of me.
Thank you. My lady, Mr. Attridge, his worship directed his mind to Hill and Baxter and Dunn on page on paragraph 18, my lady.
Yes.
Right?
Page 10 of the record and page paragraph 13 in his judgment.
Yes, you have 13 paragraph. It begins and paragraph 14 of the man is citing Hill and Baxter states, and he goes through Hill and Baxter's facts. Does my lady have it?
Yes.
Yes. No need to. We all know the facts. If we go to the page of that judgment, that drivers do fall asleep is not uncommon cause of serious road accident. This is still Lord Goddard. And it would be impossible as well as disastrous to hold that falling asleep at the wheel was any defense to a charge of dangerous driving. If a driver finds that he is getting sleepy, he must stop. That's the Goddard injunction, operating on Mr. Attridge's mind. He goes on, I agree, etc. I am content, the last three lines, my lady, to rest my judgment on the ground that there was no evidence which justified the justice's finding that he was not fully responsible in law for his actions and that his intention was immaterial, that there was an absolute prohibition, again, operating on the worshipful Attridge's mind. Mm-hmm. I don't want to keep you in suspense. I can't point to his judgment that says, applying Hill and Baxter. My grounds of appeal were that the judge was misdirected himself in his reliance on Dunn, produced by my learned friend for the DPP, Ms. Simons, and his reliance in his judgment on Hill and Baxter. And it shows he relied on it because he took no account, my lady, of the Gosnell principle that fault must play a role, or that, and this is the third tone setting point, that in Bermuda, a careless driving charge under 37A, the court must leave it open to the driver to, he's entitled to avoid the inference of a court from his driving that it fell below the standard of a prudent and competent driver, and by proving some special fact relevant to the question of fault. These are the things that we complain the lady, the worshipful magistrate, failed to do. So these were material non-directions. He drew the inference that by winding down the window in St. David's to get fresh air, and that by putting on loud music, Mr. Roberts was presumably fatigued. Mr. Roberts will say—
Scott, let me interject, and it may remind you of when we were last convened on the 30th of October. The real problem that you have, the real challenge that you face, is that the evidence at trial was that your client was falling asleep. He was sleepy. There is, as I understand it, there is no real contention on the legal principle that the period of time, the time frame that is most critical in cases such as this, is not when the person is falling asleep, but the period which immediately precedes it. That was the ratio, as I understood it from your discussions, in Jimenez, and I think followed in, I've forgotten the other cases that you would have.
Cruz and
yes.
Cruz.
And this was I think the central principle that you rely on, except the evidence doesn't help you.
It does indeed.
Because if you would just be reminded, when we were looking at this on the 30th of October, I was shown the transcripts of Mr.
Roberts'
evidence, and the prosecutor took me to, I think, quite a few. Let's look at the record and see it. I see it starts on page, well, I don't know if I have a record reference for it, but I have it in front of me. You should have it in front of you.
I do, my lady.
Page 4, my lady, page 4 of the transcripts.
Of the transcript itself.
Yes,
Thank you.
near the bottom.
Yes. Are we going to go to it, my lady?
Well, I mean,
No, I take the point. May I say this?
this is why, Mrs. Scott, sorry, if I can just finish. This is why I was expecting for you this afternoon to address me more on the evidence than on those legal principles.
All right.
The legal principles, I think, were
Exhaustively covered.
well, that's probably fair. They were fully dealt with, but I was concerned, given the passages that the prosecutor referred to, that the evidence didn't support the principles that you're relying on.
My lady, may I take it this way? The evidence of falling asleep, all be they clear, even out of the mouth of Mr. Roberts, that I nodded in and out. I was feeling falling asleep. My lady, that by itself cannot be taken as evidence of proof of an imprudent driver. I've indicated that he was a competent driver. It cannot be, otherwise we fall into the malaise, the legal malaise of the Goddard principle, which is that these offenses are absolute and of strict liability. And precisely as our complaint is precisely that, having seen this judge, having seen those words in testimony, calculated that that was enough for careless driving, and took no account, a material non-direction and a miscarriage of justice, took no account of the fact that, and I remember your ladyship took the judicial notice of the number of places to stop along Aspen Park was the central theory of the prosecution. You could have stopped earlier, and the inference being avoided this accident. Milady, there are on the road from Aspen Park to the curb where the impact took place. There are a number of points. There are sidewalks. They are not lay-bys. They are grassy sidewalks. And the court, and I urge this on my lady, you, my lady, cannot place any higher value on the selection of points to stop by Mr. Roberts than the point that he did select in his mind, which was a safe lookout at overlooking Wortlong Bay. To do so, my lady, would
What if he had
introduce.
chosen Barnes Corner?
What if he had driven to Browne-Scott, coming on the
What if
middle
he
road?
had chosen Barnes Corner? Are you saying that I can, I could not assess the time frame that it took for him to pull over, even if it was as far as somewhere in the area or proximity of Barnes Corner, Somerset? I mean, at what point would I not take into consideration how long it took him to pull over?
Milady, all that Milady is required to do in law, following the law, is to take account of any effort. I won't call it a defense. It isn't called a defense in the law. Any effort by the accused to avoid the inference of imprudent driving by drowsiness, onset, and not stopping. In other words, not stopping does not ipso facto amount to imprudent driving. And if the courts were to do that, they would be affirming Lord Goddard's 1952 injunctive that when you get sleepy, you must stop. That would cause chaos on the road. I've been sleepy a number of times with the onset of sleepiness from Miles Market to home. And I've made it home, which is why the reason he had an honest and reasonable belief that he would reach the lookout at Wortlong Bay, one of the places to stop, in addition to those which Milady said you are entitled to take judicial notice of, as existing on the stretch from Essex Cove to the point of impact. May I reiterate with force, Milady, that no special value can be assigned to any of the prior points of stop. Every same value must be applied to that grassy verge set of stops to the point of the Wortlong Bay. That would be fair. Otherwise, you are substituting by rear view mirroring that the accident would have been avoided by stopping earlier. And no counsel, my learned friend, can't make that conjecture, but it was up to the worshipful Mr. Attridge to take that into account. But he sailed through. It was so apparent that he was applying he said he was feeling sleepy, therefore I can conclude that he was falling below the standard and of a prudent driver. When that amounts to Hill and Baxter strict liability. Milady, the law of this country cannot fall from your pen today or whenever it does do so, that we support Hill and Baxter absolute strict liability. It must be clear. May I say this, and I'll almost round up. Milady, even as we go through these cases, and my friend Ms. Simons and I, as counsel, have a vast body of legal experience, we have come up with very few cases on drowsy motorist driving across the world and in this country. So I believe that I say with respect that it is important. Your decision will be a guiding principle. And as a guiding principle, I empathize with you. Your decision in Lauren Davis is helpful in that you say that a subjective and objective test is necessary. My lady, may I say this right away? Subjective test immediately introduces the lawful or the legal requirement for the court, and for my lady, may I say, to take into account this effort by Mr. Roberts to raise his explanation to avoid the inference. His explanation was, I put it in my mind, knowing that I was falling asleep, to get to a safe space where I would not attract the attention of anybody. Parking on the verge, which is a grassy walkway, or anywhere else, pulling into a hotel parking lot, he felt would attract attention, would attract undue attention. And so that's how he said, I made a decision, Your Worship, to avoid what he determined was danger by driving whilst feeling drowsy. And so that's what was the non-direction and a material non-direction of this judge. If we go through the judgment, and as you do so when you consider this matter, you will see nowhere that Mr. Attridge directed his mind to these kinds of considerations. It was done, it was Hill and Baxter, and a conclusion that the evidence that I was nodding in and out, and I was beginning to feel sleepy earlier on down by Brenda's, was enough. And that's our complaint. Unless I can assist the court.
No, I would commend you for having kept the time frame that you indicated you would stay within.
I'm grateful. My lady, I did send you some, and this is with your leave. I invite my friend and my lady to look at how the world is handling this issue by just looking at the signages. Drowsy drivers next exit 2 miles. I mean, there's an inference even in the administration of this problem that some distance is being allowed for drivers to get to a safe spot. That's those are my submissions, my lady.
Thank you, Mrs. Scott.
I'm grateful.
Ms. Simons?
Yes, my lady. You have before you the submissions, the amended submissions from the Crown that was submitted on March 6th.
Yes.
Is there anything in particular that you wish me to focus on?
Well, I mean, I have been pretty open with Mr. Scott during his oral submissions about my concerns that the evidence as laid out in the transcripts seem to suggest that the appellant was in an extended period of sleepiness. You might want to address me on the evidence and what inferences I can draw from the point where he the point where he says that he started to feel sleepy, and then when he actually did fall asleep.
Yes, my lady.
Can I draw from the evidence from those two things?
Yes, my lady. In that instance, if I can first take you to the transcript, page 4, near the bottom, I'm going to start with the second to last time that Mr. Roberts speaks. And it starts with, okay, well, as I left St. David's.
Yes.
Okay, so he says, okay, as well as I left St. David's, I was traveling behind a couple of cars, feeling fine, listening to music, had the windows wound down, catching some fresh air. As I was making my way, as I got close to Paget, I found myself feeling like drowsy, tired. So that's before he even approached Paget, he started to feel drowsy. He said, like I could feel myself getting tired. So I still made my way to South Shore Road. And as I got along Aswood Park stretch, just by the guest houses there, I started to nod off. So at the guest houses, so he felt tired before he got to the Paget area. Then he reached the guest houses, and that's when he started to nod off and fall asleep. And he still continued to drive. He still continued to make the decision to travel even further. And he went on to say that that's when he made his conscious decision that he was going to pull off at Work Long Bay and to rest and take out his camera. I note that in the evidence, Mr. Roberts makes mention that he's pulling over to take out his camera, take some pictures. That wouldn't require the amount of space that I believe my learned friend had said if he was pulling over to fall asleep in his car. He says in his evidence that he's pulling over to take pictures, to stand outside of his car and take pictures, not to fall asleep. That means there was a lot more places in which he could have stopped on that stretch to just hop out and take pictures. So my lady, I believe the evidence was very clear of what he said whilst he was on the stand, and the evidence in which the learned magistrate made his decision. If I can go now to my submissions, and I just want to touch on, to start with, if we can turn to page 2, the top of page 2, paragraph 4. And that's where we have the reference to croon, which is found in page 4 of Jimenez, is what leads to the reference to cruise. And that should be at your tab 1, I believe, my lady, in your bundle.
Yes.
Okay, and it says at that page that if a driver who knows or ought to know that there is a significant risk of falling asleep at the wheel continues to drive the vehicle, he is plainly driving without due care and may be driving in a manner dangerous to the public. If the driver does fall asleep and death or bodily injury results, the driving prior to falling asleep is sufficiently contemporaneous with the death or the bodily injury to be regarded as the cause of death or bodily injury. The case must be rare in which a driver who falls asleep can be exonerated of driving without due care and attention, at least in the moments preceding sleep. As you mentioned earlier, my lady, we're focusing on the moments before he actually fell asleep. Mm-hmm. And we say that those moments are critical. And we say it was in those moments where his decision-making was careless, where he fell far below the standard of a careful and prudent driver. Mm-hmm. So I just want to touch on the case of Kaylin Mabry, my lady, that my learned friend brought your attention to.
Well, what I brought my attention to, correct me if I'm wrong, was a transcript of closing submissions by counsel.
Yes, my lady, and we would say that that bears no weight. Yes, and we are agreeing that it doesn't bear any weight to the court, the mm-hmm. closing submissions of Mr. Daniels, I believe it is.
Mm-hmm.
Yeah, I'm not taking that point either, my lady. I didn't make that point.
Thank you, Mr. Scott. Ms. Simons, I think what would also assist me is if you could, in looking at the judgment of Mr. Attridge, just address me directly in response to Mr. Scott's complaint that Mr. Attridge erred in his reliance on cases such as Hill and Baxter. I'm looking at paragraph 18 of his judgment. Or thereabouts. So my question would really be twofold. Number one, did the magistrate in fact err in his reliance on legal principles which are antiquated? And my second question is, even if he did so err, does the evidence in any event meet the threshold in support of the conviction that he imposed?
Yes, my lady. I'm going to start with the second part of your question because I think that's an easier answer. Yes, the evidence does support the conviction. The evidence that was before the court at the time, the evidence that came straight from Mr. Roberts supports that of careless driving.
Mm-hmm.
the standard of driving where he says that he starts to nod off, he falls asleep. There was ample time. And I believe the court took that into consideration where he could have pulled over, where he could have avoided any situation by just deciding to stop. But he decided to stop at quite a distance. And that's what caused the issue that we are in, the accident that we are in. And he says even further down that he was, if I can just, he said that he was extremely tired. If you go to page 11 of the transcripts during my cross-examination,
Yes.
about midway down the page, he says, no, I said I was fine. I only felt tired, extremely tired.
Well, I mean, beyond extremely tired, he's already given evidence that he was nodding off.
He was nodding off. So when he said extremely,
sorry, surely there's a difference in degree between someone who is feeling sleepy, as Mr. Scott described it, and someone who is actually nodding in and out of sleep prior to pulling over.
yes, my lady. Yes, my lady, I would agree. If we go now back to your question regarding Hill and Baxter,
Yes.
the learned magistrate properly applied what was mentioned in Hill and Baxter. If we go to page 4 of Hill and Baxter, my lady, I believe that's your tab 2.
Let's see. My tab 3, yes.
Yes, and if we go to the page 4, the top paragraph, midway down the top paragraph,
Yes.
in the judgment, it says that drivers do fall asleep is not uncommon cause of serious road accidents, and it would be impossible as well as disastrous to hold that falling asleep at the wheel was any defense to a charge of dangerous driving. If a driver finds that he is getting sleepy, he must stop. My learned friend keeps using the phrase that the learned judge used, he must stop, that he must immediately stop in the middle of the road. It seems like he is trying to put forward to the court, when I believe that's not the case in this judgment. I believe that this judgment is saying he must reasonably stop.
Mhm.
As it goes further down the page, I want to say 3/4 of the way down the page, there is a sentence where he continues it. It says, there was no evidence that he was suffering from anything to account for what is so often called as a blackout, and which probably, if genuine, is epileptic in origin. There was no evidence before the court that Mr. Roberts had any sort of medical issue, that there was anything that was untoward that caused this to happen, other than the fact that he's had minimal sleep. He spent a very long time working overnight and then working a full shift during the day, and he was tired. I believe Hill and Back.
Remind me of the evidence. Hadn't he traveled the previous day, and what was the evidence in relation to his return?
Travel. Yes, my lady. He had traveled back, I believe, from Miami that evening.
Mhm.
And went home. I think he said he had something like maybe an hour or so of sleep on the plane.
Mhm.
He went home and then he went to work.
Mhm.
On leaving work,
5 hours. 5 hours.
5 hours
5
on the
hours from
plane.
Florida. Yeah, there was a 5-hour trip from Florida.
Sorry, what are you saying was 5 hours?
The lady from Miami to Bermuda, it's a 5-hour trip.
The length of travel, yes, okay, thank you.
My lady, the flight from Miami to Bermuda isn't 5 hours, but I hear my learned friend. So he went to work, and then after work, he went back home and then went to his next job, which was security, I think, at the carnival that was happening in St. David's. So it was minimal sleep that he was operating in that day.
Mhm.
That was the evidence as it relates to that.
So sorry, what is this 5-hour description of that Mr. Scott is referring to?
Sorry, my lady, I'm told by my client, the trip from Miami to Bermuda is 2.5 hours. Not 5.
I just want to know what the evidence was. What was the evidence? And I think the prosecutor is probably quite able to respond to this. What's the evidence, or what inferences can I draw on the evidence in relation to his recent return from Ireland? Because I recall I was invited to draw some inference or attach some significance to it. And if I am not, how did the magistrate deal with it?
Yes, my lady. If I can take you to page 2 of the transcript, and we will be, let's see, about 60% down the page, after Mr. Attridge said, "So you arrived back in Bermuda from Miami where?" Mr. Roberts says, "I was looking at schools in Miami, Florida for plumbing, specifically Miami School of Science and Technologies. I landed back in Bermuda at 10 p.m. 10 p.m. is correct." Then he goes on to say that he goes to a concert at the National Sports Center for 11 or 11:30 or 12, somewhere between 11 and 12, to do videography.
Right.
If you turn on to the next page, he continues with his timeline, my lady. And he says he can't remember exactly what time, between 11 and 12. It says, "When I got off the plane, I got right home, bathed, grabbed my equipment, ran, picked up one of my coworkers, and or one of my workers to help me with it, and we went to make our way to National Sports Center." If you go down a little bit more in that same paragraph, it says the whole concert, I would say, I think it a bit inaudible, 4:30ish, 5. I didn't get home until about 5. So I left there at 4:30, and it was about 5 when I got home. Then he says, if you go down some more, that I had only had about 2 hours of rest. And at 7, I made my way to St. David's for my security gig.
I think that's the answer to my question. I recall there had been some emphasis on how much time of rest he would have had post-travel.
Yes.
Okay.
Yes, my lady. So it is our submission that the learned magistrate did not err in law, and that he also properly applied the principle that was in Hill and Baxter.
Okay.
My lady, did you have any other questions that you wanted me to address?
Remind me, sentence has been stayed in this?
Yes, my lady. The sentence has been stayed.
All right. I would now give Mr. Scott the opportunity to reply on any points of law arising.
Sure. On a matter of law, the test enunciated just moments ago by my learned friend of what amounts to prudent driving. She says that he must reasonably stop. She was dealing with how much continued driving he dealt with. But that is precisely our point. The test, even out of my friend's submission, is that he must reasonably stop, which takes us to this point, which is Roberts' case. He estimated that it was reasonable for him to stop at the point designated in his mind. That's the first point. Another way that Milady judges must assess driving falling below standards is examining any underperformance of the driving but prior to impact. That was what happened in Hill and Baxter. The car was erratically driving. The truck was erratically driving up to the circus on the highway. None of that is there. But my lady, you do have guideposts to assist you from reaching a conclusion on thin evidence of falling below the standards. You asked my friend for the evidence. It was evidence not from any independent witness that she called, but entirely from Mr. Roberts, only and exclusively. So that makes the case a little more difficult. Finally, milady, on points of law, I don't know if you've noticed, milady, that this morass of assessing careless driving is entirely dependent upon, even in the English cases, on principles of dangerous driving. But I wish you good luck. I think you are on a strong analysis wicket by, as you indicated in Lauren Davis, that it is a mixed test, both an objective and subjective test when assessing careless driving. But as I said, my friend and I have only been able to give to you 2 cases, Dunn, Jimenez, the rest are American cases, 1932 I've looked at, of drowsy driving. And so it becomes an important decision for you to lay down guidelines for future drowsy motorists in this country. So those are my views.
If I dismiss the appeal, I would remit it for sentence before the magistrate. And if I allow the appeal, I would have to address my mind to the issue of a retrial. Do you want to
Briefly, yes, my lady.
invite
So,
me to consider that briefly?
all right. Shall I, myself first, my lady?
Mhm.
Yes. So in Jimenez, that very same, the court reached the,
This aside, I'm not.
Oh, I'm sorry.
A repetition of all the principles that I've heard. No,
ad nauseum.
I didn't want to use that term, but certainly quite thoroughly. Thank you.
No. The judges in Jimenez were dealing with the same thing. They decided that they would not, after a lengthy period,
Mhm.
put a retrial. They simply would make the decision. I invite you to look at Jimenez in the very last paragraph of the first justice, I think it's the Chief Justice, and see how he rationalized not sending it back for retrial. Adding to that, of course, Mr. Roberts is a young Bermudian who has been put through expense and the uncertainty of whether he can continue to operate as a security officer by losing his license for this, causing grievous bodily harm. We do not discount the seriousness that took place there. And to put him through a retrial and the expense of it is something that we invite the court not to do, should you allow the appeal.
Okay.
I hear what my lady has said, that if you dismiss the appeal, you would send it back to the magistrate.
Okay. Ms. Simons, do you deem it necessary to add anything to that? You're on mute, Ms. Simons. Sorry.
Unmute, Ms. Simons.
Thank you, my lady. Of course, it would be the Crown's submission that this appeal should be dismissed, but if you were to allow the appeal due to the gravity of the injuries, thank you, my lady, to the complainant, we would have to, I believe, in the interest of justice, go forth with a retrial.
And
All right, my normal course is to reserve judgments to provide a written decision in criminal appeals, and I will follow that standard approach. You will hear via the registry when I have a draft judgment available for your editorial input. It is hoped that that will be within the standard 6-week time frame. But as we near year end, there are many matters on the list for reserved judgments, and so the court will have to advise you if it is likely that we will go beyond that 6-week time frame.
all right.
Okay.
I'm very grateful, my lady.
Otherwise,
grateful, my
Lady,
lady.
I'm grateful.
thank
Thank
you.
you, ma'am.